Committee will come to order. Without objection, the chair is authorized to declare recess at any time. We welcome everyone to today's hearing on oversight of the Office of Special Counsel Jack Smith. The chair now recognizes the gentlelady from Florida to lead us in the Pledge of Allegiance. We'll begin today's hearing with opening statements. The chair is now recognized for an opening statement. It was always about politics. And to get President Trump, they were willing to do just about anything. January 7th, 2023, Kevin McCarthy becomes Speaker of the House. 16 days later, Jack Smith issues a subpoena for his phone records. Phone records from 2 years prior for a 2-month time frame, Election Day 2020 to January 7th, 2021. Jack Smith and the Biden Justice Department get the phone records of the top Republican in government, the guy second in line to the president. They know who he called, who called him, when the call took place, and how long it lasted. You can pattern an individual's life. They know who the speaker talked to before big votes, who he talked to after big votes, when he calls his colleagues, when he calls his family. And to add insult to injury, they go to the judge with the subpoena for a gag order on the carrier. AT&T, don't tell your customer, the Speaker of the House, that you just gave his phone calls to Jack Smith and Joe Biden. And here's the kicker. They say to the court, we need this gag order because he's a flight risk. Someone might tamper with witnesses or with evidence. Are you kidding me? The Speaker of the House is going to run? They got my phone records for 2.5 years. Even the Democrats said this was wrong. But of course, we shouldn't be surprised. Democrats have been going after President Trump for 10 years, for a decade. And the country should never, ever forget what they did. Over the next few hours, we're going to hear a lot of yelling and screaming, I assume, from the other side. But we should never forget what took place, what they did to the guy we the people elected president twice. It all started in 2016 when they spied on his campaign. The Clinton campaign hired the law firm Perkins Coie, who hired the public relations firm Fusion GPS, who hired a foreigner, Christopher Steele, to put together the fake dossier. Bunch of garbage in that document, but that was used by Jim Comey's FBI. And we all know Jim Comey. He was the guy who just last year was strolling along the beach when the good Lord had the waves wash up on shore seashells in the formation of 8647. That guy took that dossier to the FISA court, lied to the court, and then spied on the other party's campaign. This, of course, led to the Mueller investigation. 2.5 years, 19 lawyers, 40 agents, $30 million to find nothing. No conspiracy, no coordination whatsoever. Then it was impeachment 1, the anonymous whistleblower. We couldn't even know who was bringing the charge against the guy they were trying to take it, the guy we elected, who they were trying to kick out of office. We couldn't know. Secret hearings in the bunker, in the basement of the Capitol. Again, nothing. Then it was impeachment 2. No secret hearings here because they didn't have any hearings. It was a snap impeachment, and the Senate trial actually took place after President Trump wasn't in office. Then, of course, it was Alvin Bragg, who said before he got elected district attorney that there was no case here. Then he gets elected and changes his mind when the left starts pressuring him to go after President Trump. He hires Michael Colangelo, former Democrat National Committee consultant, and the number 3 guy at the Department of Justice. And then, of course, it's Fani and Nathan, Fani Willis and Nathan Wade in Fulton County, Georgia. We actually deposed Mr. Wade, one of the most interesting depositions I've sat through. We said to him, you know, you billed taxpayers in Georgia thousands of dollars for meetings in D.C. with the January 6th committee and with the Biden administration. And we asked him some questions. Who'd you talk to, Mr. Wade? He couldn't remember. We said, where'd you meet? Did you meet the Capitol? Did you meet the White House? Where'd you meet? Couldn't remember that either. We said, were these meetings in person, on the phone, or did you have a Zoom meeting? Couldn't remember, couldn't remember, couldn't remember. We finally just asked him, did you really come to D.C. and meet people? He said, oh yeah, I came, and I billed the taxpayers. I know I came. Just no idea who he talked to or what he did. And then there was the raid on President Trump's home, you know, where they searched Barron's room and the First Lady's closet. In our deposition with Stephen D'Antuono, head of the FBI Washington field office, he told us none of the normal process, none of the normal protocol was followed in the investigation. He said, first of all, the case was run out of D.C. Normally you run it out of the Miami field office. No, we're going to run it out of D.C. He said he recommended, and the people in the FBI at the time in the Washington field office recommended they give the president notice before they do the search, or at least when they got there, before they start the search, call the president's lawyers, ask them to come there and meet them and conduct the search together. Again, the answer from Maine Justice was no. Which brings us back to Mr. Smith. On November 18th, 2022, 3 days after President Trump announces he's running for president, Attorney General Garland names Jack Smith special counsel. One of the first things Mr. Smith does is put on his team the very people responsible for the raid on President Trump's home. The very people. And then Jack Smith also puts on his team the people responsible for getting the phone records of dozens of members of Congress. People like Thomas Wyndham, who, when we deposed him, took the fifth 71 times. We've actually referred him to the Justice Department for obstructing our investigation. Jack Smith then gets a gag order in his investigation on President Trump from Judge Chutkan without filing a single affidavit with the court from a witness or a potential witness that they felt threatened by statements from the president. Stop and think about it. Jack Smith restricts the speech of the former president while he's a candidate for president. Thank goodness Mr. Smith was slapped down on appeal and the order was changed. In fact, just 2 weeks ago, the Washington Post editorial page, Jack Smith would have blown a hole in the First Amendment. I just want to read 2 sentences from this. Mr. Smith seemed unconcerned about interfering in the democratic process by seeking to muzzle a candidate for high office. 3 appellate judges, all nominated by Democrat presidents, ruled that Mr. Smith's proposed gag order infringed on President Trump's First Amendment rights. And of course they did. And this wasn't the only time Mr. Smith lost in court. In the classified documents case in Miami, Judge Cannon held that Mr. Smith was not permitted to be special counsel. Jack Smith was never properly appointed. In fact, he couldn't be properly appointed because he was never confirmed by the Senate for any position in the executive branch as the law requires. Here's what Judge Cannon stated. Quote, the special counsel's position effectively usurps that important legislative authority, transferring it to a head of department and in the process threatening the structural liberty inherent in the separation of powers. And of course, on July 1st, 2024, the United States Supreme Court ruled that President Trump had immunity for actions taken in his official capacity as the president. 1 month later, after this decision by the Supreme Court, Jack Smith files a superseding indictment on August 27, 2024. But Mr. Smith doesn't stop there. He does something unprecedented. On October 2nd, he files a motion with the court before President Trump's defense counsel has even responded to the indictment. Everyone knows the normal process is the government indicts, the defense responds with some motions, and then the government responds to the defense. But Mr. Smith skips the second step. And the brief that he files is 165 pages, almost 4 times the court limit. Even liberal Judge Chutkan, who's given Jack Smith everything he's asked for in the course of this investigation, even she called it atypical and irregular. Now, why would Jack Smith do that? Why would he abandon proper procedure Why would he ignore court rules? Why would he do that? Because he's running out of time. There's an election around the corner. It's coming in 33 days, and he's got to get President Trump. He's got to stop President Trump from running, tie him up in court. He's got to get to trial, or at a minimum, insert an 165-page political document into the presidential campaign. It was always about politics. The good news is the American people saw through it. They saw through it. For so long, the left has controlled so much in this country. The left controlled big media, the left controlled big tech, the left controlled academia, Hollywood, certainly the Democrat Party, and I think all too much the federal bureaucracy. But the left doesn't control we the people. And in spite of the left and the weaponization efforts of Jim Comey, Alvin Bragg, Bonnie Willis, and Jack Smith, we the people saw through it all. And we elected President Trump twice. Before turning to the ranking member for his opening statement, I would just ask unanimous consent to enter into the record the Washington Post editorial, Jack Smith would have blown a hole in the First Amendment. With that, I yield to the gentleman from Maryland.
Well, thank you kindly, Mr. Chairman. I want to start by recognizing the presence of four American heroes here today, four of the hundreds of officers who defended us on January 6, 2021, Michael Fanone, Aquilino Ganell, Daniel Hodges, and Harry Dunn. And I thank them for being here today. Mr. Smith, thank you for appearing before the American people. I'm glad that the committee has finally granted you the same chance to report your findings to the American people that every other special counsel investigating an American president has had. The good chairman started by saying it's all about the politics. Well, maybe for them, but for us, it's all about the rule of law and who's going to stand by the rule of law and who's going to oppose it. Now, Mr. Smith, you're one of America's great prosecutors. For nearly 3 decades, you worked for justice under both Republicans and Democrats. The Manhattan DA office, where you prosecuted sex crimes and domestic violence cases. The Eastern District of New York, where you prosecuted murderers, rapists, gangbangers, and other violent criminals. Leading the public integrity section at the Department of Justice, you brought prosecutions against corrupt public officials across the political spectrum. When you went to The Hague as chief prosecutor in the Kosovo trial, you prosecuted war crimes and crimes against humanity perpetrated against thousands of innocent victims. While others may have devoted their lives to corrupt self-enrichment, you have devoted your life to the rule of law and to public service. You've never been prosecuted for anything. You've never been convicted of anything. As far as I can tell, you've never even been the subject of a disciplinary proceeding over the course of your multi-decade career. But Donald Trump says you're a criminal and you belong in prison. He says you belong in prison, not because you did anything wrong, mind you, but because you did everything right. You pursued the facts, you followed the law, you stuck with extreme caution to every rule of professional responsibility. You had the audacity to do your job. Everybody here knows what you did wrong in Donald Trump's eyes and why he says you belong in prison. You found, and I quote from your sworn testimony before the committee, you found proof beyond a reasonable doubt that President Trump engaged in a criminal scheme to overturn the results of the 2020 election and to prevent the lawful transfer of power. When asked whether you believe the evidence was enough to obtain a criminal conviction against Donald Trump at trial, you had a one-word answer: yes. When asked if Donald Trump was responsible for the violence that took place at the Capitol on January 6th, you said, our view of the evidence was that he caused it and that he exploited it and that it was foreseeable to him. You found that Trump knew he had lost the election. How? Well, his own Attorney General, William Barr, repeatedly told him so and described all of Trump's theories as BS. Trump's top campaign advisors told him he lost the election. Vice President Pence told him he lost the election. More than 60 federal, state, and court decisions, including 8 rendered by judges he appointed to the bench, rejected every outlandish election fraud and corruption claim that he made. Trump himself even privately acknowledged it, gesturing to Joe Biden on TV and saying, quote, "Can you believe I lost to that effing guy?" He knew he lost, but he threw everything into his big lie, which some people, even in this room to this day, will stand by and swear by. Well, when the big lie wasn't enough to convince officials like Georgia Secretary of State Brad Raffensperger, a Republican, to commit election fraud and just fine Trump 11,780 votes, when it wasn't enough to convince Trump's DOJ to, quote, "just call the election corrupt and leave the rest to me and the House Republicans," when it wasn't enough to force Vice President Mike Pence to announce and then exercise lawless powers to reject Electoral College votes and use counterfeit slates to anoint Trump the winner, that's when Trump incited mass violence on January 6th. While more than 140 officers were being brutally assaulted by Trump's mob, while rioters beat them with flagpoles and sprayed them with chemical agents and crushed them in doorways, and while they chanted, "Hang Mike Pence," and chased the vice president out of the Capitol, Trump and his team worked the phones, calling not the National Guard, which was under the direct unilateral control of Donald Trump, but calling members of Congress, urging them to delay certification and to nullify the election results. Special Counsel Smith, you pursued the facts. You followed every applicable law, ethics rule, and DOJ regulation. Your decisions were reviewed by the Public Integrity Section. You acted based solely on the facts, the opposite of Donald Trump, who now has purported to take over the Department of Justice. He's in charge of the whole thing under his unitary executive theory, and he acts openly, purely based on political vendetta and motives of personal revenge, and he doesn't deny it. Our colleagues have complained about the special counsel's review of toll records, which are phone records like a phone bill, showing only the timing and duration of calls and containing no content, no substance whatsoever from the calls. But those records were lawfully subpoenaed because Donald Trump made those members of Congress relevant to the investigation. It was Trump who chose to call them to advance his criminal scheme. As you testified, Mr. Smith, if Donald Trump had chosen to call a number of Democratic senators, we would have gotten toll records for them too. I trust our colleagues get the point because America certainly gets the point. There is much Mr. Smith still can't talk about, though we know he badly wants to. His investigation developed what he calls powerful evidence that Trump stole documents containing our country's most sensitive secrets, hoarded them in the ballrooms and the bathrooms of his well-trafficked Mar-a-Lago social club. He showed them off to visitors. And then he obstructed a federal investigation by instructing his attorney to pluck out anything really bad before turning materials over to the FBI and having his staff delete incriminating security tape footage. But today we're not going to hear a lot about that because you are gagged by an absurd judicial order rendered faithfully by Trump's most servile and sycophantic appointee to the federal bench, Judge Eileen Cannon. This order not only blocks release of Volume 2 of your report, which is unprecedented, about the classified document scam, it also gags you from discussing the report or its contents with us, with America. And so we don't know what's in it, but it must be pretty devastating because Donald Trump is desperate to keep Mr. Smith or any other DOJ official for all time from ever releasing it to Congress and to the American people. Now, Mr. Smith, if any of our colleagues foolishly choose to attack you and vilify you today, and I know that's not going to happen from some serious prosecutors over there like Mr. Knott and Mr. Schmidt, who understand what federal prosecutors do and what the rule of law means. But if anybody decides to attack you personally, they will only be revealing their own ignorance of what prosecutors do and their own indifference to what the rule of law requires in America. They will only be stroking the wounded ego of a lawless, twice impeached convicted felon president who not only unleashed a mob against Congress and his own vice president, but is now pardoned and released into our communities hundreds of extremists, insurrectionists, and cop-beating felons who have proceeded to commit dozens more crimes against the American people since they were pardoned. Mr. Smith, I understand you are a long-distance marathon runner. I read that you're a triathlete who's done more than 100 triathlons and 9 Ironman competitions. You are in the fight for justice and the rule of law for the long distance, for the long haul, and I thank you for that. And we should all try to follow your example. America looks forward to your testimony today. I yield back to you, Mr. Chairman.
The gentleman yields back without objection. All of their opening statements will be included in the record. We will now introduce today's witness. Mr. Jack Smith was appointed as special counsel on November 18, 2022. He served until January 7, 2025. We welcome our witness today. We'll begin by swearing you in. Would you please rise and raise your right hand? Do you swear or affirm under penalty of perjury that the testimony you're about to give is true and correct to the best of your knowledge, information, and belief, so help you God?
I do.
Let the record reflect that the witness has answered in the affirmative. Thank you. You can be seated. Please know that your written testimony will be entered into the record in its entirety. Accordingly, we ask that you summarize your testimony. Mr. Smith, you may begin.
Chairman Jordan, Ranking Member Raskin, members of the committee, thank you for the opportunity to discuss my work as special counsel. I love my country and believe deeply in the core principles upon which it was founded. For nearly 3 decades, I've served as a career prosecutor in both Republican and Democratic administrations. I've handled cases ranging from domestic assault and gang violence to public corruption and election crimes across the United States, and I've prosecuted war crimes overseas. I am not a politician, and I have no partisan loyalties. My career has been dedicated to serving our country by upholding the rule of law. Throughout my public service, my approach has always been the same. Follow the facts and the law without fear or favor. Experienced prosecutors know that specific case outcomes are beyond our control. Our responsibility is to do the right thing, the right way, for the right reasons. These principles have guided me through my career, including as special counsel. I'm proud of the work my team did, and I appreciate the opportunity to appear here today to correct false and misleading narratives about our work. During my tenure as special counsel, we followed Justice Department policies, we observed legal requirements, and took actions based on the facts and the law. I made my decisions without regard to President Trump's political association, activities, beliefs, or candidacy in the 2024 election. President Trump was charged because the evidence established that he willfully broke the law, the very laws he took an oath to uphold. Grand juries in 2 separate districts reached this conclusion based on his actions, as alleged in the indictments they returned. Rather than accept his defeat in the 2020 election, President Trump engaged in a criminal scheme to overturn the results and prevent the lawful transfer of power. After leaving office in January of 21, President Trump illegally kept classified documents at his Mar-a-Lago social club and repeatedly tried to obstruct justice to conceal his continued retention of those documents. Highly sensitive national security information was held in a ballroom and a bathroom. As I testify before the committee today, I want to be clear. I stand by my decisions as special counsel, including the decision to bring charges against President Trump. Our investigation developed proof beyond a reasonable doubt that President Trump engaged in criminal activity. If asked whether to prosecute a former president based on the same facts today, I would do so regardless of whether that president was a Democrat or a Republican. No one should be above the law in this country, and the law required that he be held to account, so that is what I did. To have done otherwise on the facts of these cases would have been to shirk my duties as a prosecutor and as a public servant, of which I had no intention of doing. I remain grateful for the counsel, judgment, and advice of my team. President Trump has sought to seek revenge against career prosecutors, FBI agents, and support staff simply for having worked on these cases. To vilify and seek retribution against these people is wrong. Those dedicated public servants are the best of us, and it has been a privilege to serve with them. After nearly 30 years of public service, including in international settings, I have seen how the rule of law can erode. My fear is that we have seen the rule of law function in our country for so long that many of us have come to take it for granted. The rule of law is not self-executing. It depends on our collective commitment to apply it. It requires dedicated service on behalf of others, especially when that service is difficult and comes with costs. Our willingness to pay those costs is what tests and defines our commitment to the rule of law and to this wonderful country. Thank you.
Gentlemen, we will now proceed under the 5-minute rule. We have votes coming in any minute now, but I think we'll have time for 3 or 4 members to get their 5-minute questions in before the committee will take a recess to go vote. They are not going to close the vote until we get there. I know that much. So we will start with the gentleman from California. You're recognized for 5 minutes.
Good morning, Mr. Smith. When Attorney General Garland appointed you, he cited the particularly sensitive matters at issue and extraordinary circumstances as the reason for appointing a special counsel. What did you take that to mean?
What I understood that to mean is I was to conduct an independent investigation and come to my own conclusions about whether the facts and the law supported a prosecution.
But clearly he was alluding to the fact that we had an investigation into a leading candidate for president. That was part of the extraordinary circumstances. Would you agree?
I will rely on his public statements about that. I understood my role as special counsel was governed by the regulations, which required me to make an independent decision on my own.
So certainly you would agree it was important to approach the investigation with humility and restraint. Is that fair?
Yes, and that's what I sought to do. I sought to
conduct... And you thought you possessed those qualities. In fact, you testified at your deposition, quote, "I thought I was the right person for the job." Of course, some disagreed. Constitutional law professor Jonathan Turley, for example, has said, quote, "Jack Smith has a reputation for stretching criminal statutes beyond the breaking point." I assume you disagree with that statement by Professor Turley.
I do disagree with that statement. I think my career speaks for itself. I have been.
But that statement was also, and I'm sorry to have to interrupt, I just have a short amount of time. That statement was also echoed by the United States Supreme Court in a unanimous opinion in McDonald versus the United States, where the court overturned convictions that you had pursued against a former governor, criticizing your boundless interpretation of the federal criminal statute. At issue, that opinion was joined by Justices Ginsburg, Breyer, Sotomayor, and Kagan. So do you also disagree with that statement by those justices?
I have conducted my career in a nonpartisan fashion. That particular case, the legal position that the department took, that wasn't my personal position. That was the position of the department.
I see. So, Mr. Smith, I've had the opportunity during my time on this committee to review the work of 2 special counsels, John Durham, appointed during the Trump administration, and Robert Hur during the Biden administration. And in both cases, they seem to exhibit that humility and restraint that we talked about. But in reviewing in detail the way you conducted this investigation, I see a very different mode of operation. One that sought maximum litigation advantage at every turn, one that repeatedly circumvented constitutional limitations to the point that you had to be reined in again and again throughout the process. For example, shortly after you became special counsel, you issued a subpoena for the phone records of the Speaker of the House of Representatives over a 2-month period, along with for other senators and representatives, even though the public integrity section at DOJ cited litigation risk to doing this. What was that litigation risk?
With respect to the toll record subpoenas that we issued, they were approved by the Public Integrity Section. The Public Integrity Section, in approving those subpoenas, noted the fact that the subpoenas were for records for people who were not targets of our investigation.
But they said there was a litigation risk and you moved forward with it anyway. And not only that, but you also sought orders from judges making it so those who were having their records seized would not know about it. And you even didn't tell those judges that it was members of Congress whose records you were going after, in apparent contravention of a federal statute saying that a telephone provider for a Senate office shall not be barred from providing notice that the records had been requested. Now, if you sought to do that today, would you be able to get away with that, with asking the judges for a non-disclosure order without telling them these are members of Congress?
When we secured these toll record subpoenas, it was done consistent with department policy. You're correct in that that policy has since changed.
They changed the policy based upon the actions that you took. Similarly, you issued a gag order against President Trump that the D.C. Circuit Court of Appeals vacated as overbroad. Is that correct?
Well, the D.C. Court of Appeals, in passing on that order, found that it was justified. They narrowed the order, but they confirmed that the phenomena—
They narrowed the order because it was overbroad. In addition to that, you sought an early trial date that the district court rejected, and when you presented your prosecution memo to Attorney General Garland, it's been reported that he was visibly unimpressed and expressed First Amendment concerns. So, Mr. Smith, looking at the record, I see that you were reversed and rebuked by the Department of Justice itself, by the Attorney General, by the Solicitor General, by multiple district court judges, by the Court of Appeals, and by the U.S. Supreme Court itself. So my final question is, do you believe that you made any mistakes? Do you have any regrets as to how you conducted this investigation?
If I have any regret, it would be not expressing enough appreciation for my staff who work so hard in these investigations. We followed the facts and the law. These people who work for me sacrificed endlessly and have endured way too much for just doing their job. So if anything, I wish that I had thanked them.
Time of the gentleman.
So no mistakes. There's that humility. Mr. Chair, I yield back.
Yeah, time of the gentleman's right. The chair now recognizes the ranking member for 5 minutes.
Well, thank you, Mr. Chairman. And the good gentleman from California certainly knows, because he was a student of mine, that lawyers go to court and sometimes they win motions and sometimes they lose motions, and there's no crime in any of that. And I'm just sorry that you had to be lectured about humility and restraint by a politician, because we might not be best poised to lecture you on those particular virtues. But let's go to the toll record, since that's been raised, Mr. Smith. First of all, Congress has allowed toll records to be subpoenaed. This committee has actually tried to limit it over the years, and the senators who are whining the most over on the Republican side in the Senate, they never went along with our determination to try to limit the government's ability to subpoena toll records. So it's perfectly lawful what you did. Explain, why did you want those toll records?
We wanted to conduct a thorough investigation of the matters that was assigned to me, including attempts to interfere with the lawful transfer of power. The conspiracy that we were investigating, it was relevant to get toll records to understand the scope of that conspiracy, who they were seeking to coerce, who they were seeking to influence, who was seeking to help them.
And that's normal investigative practice, right?
In conducting a criminal investigation, securing non-content toll records, as you described, is a common practice in almost any complex conspiracy.
Okay, let's go to something else that I've been hearing over the last week by our colleagues as they've eagerly anticipated your arrival here. They've been saying that there's some kind of First Amendment defense that Donald Trump would have had to the crimes you indicted him for. Is there a valid First Amendment defense to defrauding the public? Is there a valid First Amendment defense to disrupting a federal proceeding? Is there a valid First Amendment defense to violating the voting rights of the people and cheating the public out of a fair election?
The First Amendment is something that we took seriously in our investigation, but the First Amendment does not protect speech that facilitates a crime. Speech that is used to facilitate a crime, a fraud crime in particular, is not protected under the First Amendment. The Supreme Court precedent on that is clear. This is an issue that we litigated before the district court, and the district court ruled, as I just stated, that it is not in fact protected.
And the case law is perfectly clear on this, right? All frauds are perpetrated by speech, right?
Yes.
All conspiracies are perpetrated by speech. So just because your criminal conduct is brigaded with speech doesn't somehow mean you've got a First Amendment defense against trying to overthrow the government. I mean, the people who attacked the police officers on January 6th were chanting, "Hang Mike Pence." I suppose that was political speech, or they were saying, "Stop the steal." Does that mean they've got a First Amendment defense to violent assault against the officers?
It does not.
William Barr, by the way, was somebody who was perfectly clear about that. Donald Trump's own attorney general said there's no freedom of speech that you have to engage in a conspiracy, to overthrow an election, to commit crime. He was perfectly clear about that. Back in those days, in fact, lots of people on that side of the aisle, including my good friend, the chairman, denounced the violence that took place on January 6th. The cat's got their tongue these days. My friend Chairman Jordan said, what happened last week was terrible, is tragic. It's as wrong can be, he said. Republicans, we know all political violence is wrong. I asked my friend Chairman Jordan at a rules hearing, are you also not interested in what happened to us on January 6th? He said, of course, everyone's interested in holding people accountable who did wrong. The FBI is doing that. The Justice Department is doing that, appropriately so. What do you think about the attack on the Department of Justice and the special counsel for doing your jobs?
I think the attack is unjustified. I think the people who worked with me as career public servants are people, they're part of the reason I've been a prosecutor for so long, is to work with people like that, not just the prosecutors in my office, but also the agents, FBI agents who are heroes, who have served their country not only as agents, but also overseas. I think those attacks are unwarranted based on the facts, and I think that they have no basis in who we are as Americans, as a country. I don't see attacking people like that as anything appropriate.
Thank you. And Mr. Chairman, I yield back to you.
The gentleman yields back. Mr. Smith, is Cassidy Hutchinson a liar? She was their star witness, January 6th committee, their star witness in one of those staged and choreographed hearings they paid the former president of ABC News to put together. She was, in fact, the only witness at this special primetime hearing, Tuesday, June 28th, 2022, 8 o'clock in the evening, and she told some stories. I mean, these were some stories. She talked about President lunged across the back seat, grabbed the steering wheel, tried to drive the car to the Capitol. And I just want to know, you think she was lying?
Chairman Jordan, my assessment of that particular issue is that with respect to the testimony about the president lunging towards the driver, my recollection of her testimony about that is that it was secondhand. She said she'd heard that from somebody.
You familiar with the name Tony Ornato?
I'm sorry?
You familiar with the name Tony Ornato?
Yes.
White House Deputy Chief of Operations, Deputy Chief of Staff for Operations, right? You remember what he said about it?
As I sit here right now, I do not.
Yeah, he said it didn't happen. How about Bobby Engel? You familiar with that name?
Yes, I am.
Secret Service agent who was actually in the car that day. You know what he said? He said it didn't happen. And they both said the first time they ever heard this story was when Ms. Hutchinson testified in the primetime hearing as their star witness of the January 6th committee. By the way, did you ever confirm her testimony about this particular incident?
We conducted, as I said before, our own independent investigation of all aspects of the case that we thought was relevant. We, attorneys from my office.
Did you ever confirm it? That's a simple question.
Well, we interviewed, or I should say attorneys in my office before.
Did you ever confirm the president leaping across the seat, grabbing the steering wheel, this whole concoction she brought up in the January 6th hearing? Did you ever confirm that?
Right. We interviewed another firsthand witness who was in the car who did not confirm that had happened, but also
in your deposition to the committee last month, Mr. Smith, you said this: my recollection with Ms. Hutchinson was a number of the things that she gave evidence on were secondhand hearsay. You remember making that statement to us last month in the deposition?
I did, and I was referring particularly to what we're talking about now.
Yeah, and you also said Ms. Hutchinson, regarding this particular claim, was a second or even third-hand witness. We asked you, if you were a defense attorney, how would you handle cross-examining her if she was on the witness stand? And you said, if I were a defense attorney and Ms. Hutchinson were a witness, the first thing I would do was seek to preclude her testimony because it was hearsay. You remember saying all that?
Yes, that's correct, sir.
That's correct, right? Were you going to put her on the witness stand if you ever got to trial?
We had not made final determinations as to who we were going to call as a witness. We had a large.
You were still considering her?
We had a large choice of witnesses in this case.
Are you familiar with what Washington Post reporters Carol Leonnig and Aaron Davis said in their book? They did this book, 300-some pages book on Chronicle and the whole investigation of the Justice Department. And here's what they said on page 310. They said Jack Smith had wondered whether some of Hutchinson's claims might be relied upon at trial. Still, at one point, Smith told the elections team he wasn't ready to give up on Hutchinson's account. Ultimately, however, Trump administration officials uniformly, fiercely disputed her accounts under oath. Prosecutors on your team told Smith they wouldn't want to use Hutchinson as a witness in court, and Smith agreed. Are Carol Leonnig and Aaron Davis, who wrote this, are they lying?
My recollection is that I certainly had not made any final determinations about who we were going to call.
And that's the point. That is the point. The fact that they used her in a primetime hearing and you won't rule out using her, or didn't rule out using her, putting her on the witness stand when everybody knows she wasn't telling the truth, that says it all. That's the degree the left and Democrats were willing to go to get President Trump, putting on the witness stand someone everybody knows is making it up. Everybody knows that. And you were willing to do it. By the way, you know how many times Cassidy Hutchinson was mentioned in their report, the January 6th report? Any idea, Mr. Smith?
I do not.
185 times. Someone that the whole country knows wasn't telling the truth, and you were still considering putting her on the witness stand because you had to get President Trump. And everybody can see that. We better take a recess for votes. We will resume as soon as votes are over. Back here 10 minutes after. Mr. Smith, you guys can go back to the room that you were in.